Hello. Is it picking up? Can you hear me? Can you hear everything? Is it? Are we alone out there? Wonderful. Welcome back, everybody. The time is 10:46 and we should now be live. Just for the avoidance of doubt, we are on the members' questions section of the responsible authorities case. We have asked Stuart and he's got no questions. Is that still the case? And Councillor Shrubwick?
No, not
no worries. I've got a few questions, Lorraine. Just to confirm, I mean, there's obviously a significant level of complaints here. And I think Mr. Dad's raised a good point in relation to whom was complaining how many times. Is it fair to say that 730 was the highest complainant with the thing? Okay, wonderful. And without giving kind of, I guess, any specific address away, how close to the vicinity is that?
very close,
Directly above, wonderful. Just put your microphone on for me if that's all right. So have you personally visited the It's Mustard site yourself on numerous occasions?
Yes, I have, yes.
And have you personally witnessed the noise issues?
Yes, I've been the visiting officer apart from the one, I think it was in April, but I've been the investigating officer and the visiting officer.
Wonderful. So how long have you been doing this job, Lorraine?
Hold on. Well, I've been working for Portsmouth City Council for 23 years, so 25
amazing.
years.
Great, great. And so from your experience, would you say that the venue itself is suitable for sound? So if the It's Mustard did put in the relative, precautions, do you think the venue could become suitable for sound? Or do you think it's just simply not a suitable venue for sound?
No, I don't think it's suitable for the entertainment that's being provided, as in like a DJ. It is more suited to ancillary music, like a background music type of venue.
No worries at all. And obviously, if you visited numerous of times after the noise abatement notice, did you get a reason of why the notices were being breached at all? You know, what was the feedback?
No, our procedures have changed slightly, and in that we are a lone worker now, so we no longer visit the premise on the occasion. So we just send the standard letter to let them know that the breaches have been witnessed, but we've had hardly any correspondence back to that at all.
No worries, I've got no further questions. We go on to interested parties, so do you have any questions of the responsible authorities at all in relation to what you've heard? No? Wonderful. On to the premises licence holders, do you have any questions for the responsible authorities? Yes, David?
Yes, thank you, Chairman. You won't be surprised, I do have some questions. Just picking up on supplementary of yours, if I may. When the Chairman asked you if you've been there directly to witness, and you said yes, can we just clarify that's only on one occasion? Is that right, that you've witnessed the noise?
No, it's more than one occasion.
It's from July until now, it's once, isn't it?
Sorry, yeah, since July, but previous to that I've been more than once.
In relation to your professional qualifications regarding the question around the fabric of the building, the acoustics, what the building is suitable for, would you be able to elaborate on your professional qualifications regarding acoustic, as an acoustic expert and surveyor, etc.? Could you just tell the committee what your expertise is in that, please?
I am not an expertise in a surveyor, but I have got a postgraduate diploma in noise and acoustics.
So the premises is suitable for recorded music, isn't it?
I'd say the premises is only suitable for background recorded music, ancillary to, at the moment they're providing entertainment. So I'd say that yes, they could provide recorded music, but only at a background level.
Well, obviously I'm a bit confused on how that could possibly, you could say that. I'll put my question this way. Surely you've got to be in the flat. It's not directly above. You answered the question. It was directly above, but it's not directly above. It's above to the on the left. So directly above is our accommodation. So it can't be directly above. If you're in that accommodation, someone's got to be there, and someone's got to be in the premises to do the assessment of what is suitable and set the appropriate level. And obviously that level could be background, it could be higher than background, but surely you have to have a proper acoustic analysis of the premises. You need a noise limiting device, and you need, if need be, just two sets of ears, one in one in the other, and assessing it, because that's got to be right, because you've even said in the noise monitoring report that there was witnessed, I think in July for 2 days, that it wasn't at a statutory noise nuisance level. So that's got to be right. The proper exercise is to go into both premises and set it, and that setting exercise will establish what is appropriate. Is that right?
No, what I said with regards to the noise monitoring equipment that we had in, I said there was not enough evidence. So therefore, there was not as many recordings made over those 3 days. The noise was still audible, but I wasn't prepared to call it a breach of the noise abatement notice. It was still audible in the complainant's property.
Sorry, just to interject there. So how many breaches of the noise abatement notice, just for clarity, so not subjective, not opinion, how many breaches have you got of the noise abatement notice?
6.
6 breaches, and that doesn't include the one you were just speaking about?
No.
Perfect. Sorry, David, continue.
Yes, it's fine. So, but coming back to my question, how you establish the level of music that can be permitted without causing a statutory nuisance, that exercise has got to be undertaken by being in both premises at the same time and getting the level, isn't it? That's the question I asked, Chair.
I mean, we did agree to assist them to do this. This was back in May. However, the premise licence holder, Mr Stringer, had other commitments. So,
yes, you've already said that. Look, I don't want to get confrontational. I'm just saying, and I think you've just accepted the point. The level is set based on being inside the sensitive receptor premises and the licensed premises that's generating the noise, and then you do a setting exercise to find the right level. That's not been done yet. So until that's done, you can't say for sure that it can only have background music. That's right, isn't it?
sorry. I mean, yes, to a certain point, but noise levels could have been set before we got to this stage. However, they may still be set at a background level. So although you were saying, yes, noise levels can be set, it might not be the level that the business wants them to be played at.
Yes, I'll leave that to submissions later, but you've accepted the point that, yes, I'm correct in my submission that you've got to go through that setting exercise. You say it may not be at a background level, it may not be at the level the business wants. So we'll leave it there. My next question, and obviously if I'm wrong in that analysis, please correct me, but the next thing, on the sheet you've provided, I've gone through just very briefly, and it looks like in May the only complainant was 730, and I understand it's the lady here. And then in June, there were two other complaints, 734 and 715, one complaint each. And then in July, up until the review, there were a couple of complaints from 307 315, and after the application for review came in, the 11th of July, all the complaints are solely from 730. That's right, isn't it?
Yes.
The reason I say that, Mr. Chairman, and ask you through the officer, is that your presenting officer this morning, the licensing authority, said you continue to receive complaints, but I think it needs to be qualified that all the complaints have only come from one source, one complainant, 3730. So I'm just clarifying that that's all that's happened since the review application.
Stuart, did you have anything to?
Sorry, could you remind me, what was the date of the review application again, sorry? 11th, okay.
So just, I'm doing it on, as I've just got it, so I've got some more questions, please, officer, through you, Chair. In relation to you said that you visited the premises for food safety. When you came in the premises, Joe was interviewing a prospective member of staff, doing a job interview, yes? So the visit was unannounced, is that right?
Yeah, we don't have to announce visits under the food legislation.
No, don't be defensive.
I'm just explaining. I'm not being defensive. I'm just explaining we do not have to carry out or make appointments to do a revisit.
No, that's fine. So it was an unannounced visit. That was my question. That's right. It was unannounced. It wasn't convenient at the time. How did you react? Did you react saying thank you very much, here's my details, please call again? Or did you, as we're going to suggest, you were unhappy and you stormed out of the premises because they couldn't give you the time that you wanted?
No, that's incorrect. If I was unhappy and I stormed out, I wouldn't have left my details for Jo, Miss Johnson. What I did was, I could see that she was busy. I wrote down my name, my telephone number, email address, and a couple of points for Jo. She also, when I went back to the meeting, she showed me the information that I'd left, and it was those details.
And can I ask, she says, you say that they didn't reply on many occasions. Can I ask, every time you've interacted, or the majority of the time, have you chosen to read her rights to her every time you've spoken to her? You have the right to remain silent. You have, the normal rights that you maybe see on the TV, Mr. Chairman. But have you, each and every time when you've spoken to her on the telephone, read her rights?
No, I haven't done this. This is only being sent out recently because regulatory services are considering enforcement action under the Environmental Protection Act.
So every email that's gone out since July, or if you can give me the date, has had the right saying, it'll be recorded, all the normal rights that you would have to read out. That's been done in every communication. And from what date, please?
I don't have the dates to hand, but it is possibly before the review licensing date.
Do you think that it's important to have a partnership working? So, working through together to say, okay, like this, sort out what the source of the complaints are, how can we address it, a stepped approach to enforcement. Is that the right approach, or is it sending emails and letters each and every time you communicate with a caution and warning?
Obviously, this is done at the initial stage. When the applicant fails to respond or there is a breakdown in communication, there is only so much that we can keep approaching the person that's making the noise before we turn to enforcement action, and that's the case in this situation.
Your officers are aware when they've been doing the recordings, etc. For example, I think complainant number 12 in the recording or on the in the feedback, it talks about threats regarding access road and blocking and payment for parking. Are you aware there's a major dispute at the back about access and parking on private land, and all the residents at the back are up in arms because they're parking on Mr. Stringer's land, and he said you can't park there. Are you aware of that dispute?
Only recently, not at the initial outset when the first noise complaints came in.
And just so you've got an acoustic postgraduate diploma, have you? And would that allow you to be able to give advice on, like lobby doors, treating glass, noise limiting device? That's your expertise of giving members of the licensees some guidance. Are you qualified to do that?
Yes, so obviously we do give licensed premises advice on noise limiting devices, but what we normally recommend is that they appoint an acoustic consultant so that we can work with them, because normally the applicants or the premises are, I wouldn't say qualified in noise levels, but obviously an acoustic consultant obviously can help them further.
Yes, and can you just point me in the agenda or any letter that you've written to the premises offering to give some advice or giving some advice about having a noise limiter, agreeing to have a noise limiting exercise, setting the noise, any advice about a lobby door, any advice about treatment of the glass regarding acoustic film? Can you tell me anywhere in the papers where that advice has been given, please?
Obviously, I couldn't give any advice on the acoustic glazing because I didn't know. We still don't know what the acoustic glazing is, so we can't offer any advice to see whether it needs any further mitigation measures. In relation to the lobby door, that's not even been suggested by the premise licence holder, and we did agree to set noise levels. However, that was back in May, and we still don't have any information on the equipment that's been installed.
So you've not given any advice about a lobby door, and on the 20th of May you were talking about setting exercise. What attempts have you done to, since May, so June, July, August, any email saying would like to go in and set the noise with the complainant's premises? Have you got any emails to that?
No, we haven't. It is not the local authority's responsibility to keep chasing the premise licence holder to provide us with information or to set these levels. We've asked on numerous occasions on, have you got a limiting device to set? Again, the information has not been provided.
And just very last, well, two questions left. The first is to do with how many hours do you think you've spent doing this review, gathering everything together? Have you spent from a local authority dealing with this, as opposed to how many hours would it take to maybe pop down and have a discussion about the advice? That's my first question.
Obviously, there's been numerous hours, but again, I reiterate, it's not the local authority's responsibility to keep approaching the premise licence holder and asking for information. We can only ask so many times, again, before we go to enforcement.
And the last question is that you've said that you're considering a prosecution for alleged breaches. You're saying at least 6 occasions. So it's fair to say that it shouldn't be discussed here because it would be sub judice. It's not for the committee to determine innocence or guilt of an alleged breach of noise abatement. That's a matter for the magistrates' court, and it would be inappropriate to ask the committee to make a judgment on that. Is that right?
I agree, it's not up to the committee to make a judgment under the Environmental Protection Act. It is their commitment to make a judgment under the Licensing Act with regards to the provision of entertainment.
Thank you, everyone. Ben, can you just clarify for us what weight can be put on this subject we just discussed in relation to the noise abatement notices if they've not gone to court yet?
I think you can attach the weight that you see fit. I don't see any particular restrictions to the weight that you need to attach to the evidence. It's clearly quite persuasive evidence. I would say that you have a number of residents objecting. You have professional officers that have visited and witnessed statutory noise nuisance. The bar for a statutory noise nuisance is a higher, more difficult test in relation to rather than what may or may not be considered public nuisance under the Licensing Act. You've heard that a notice was served. A statutory nuisance would have had to have been witnessed in order for that notice to have been served, and that it was followed by 6 breaches.
Thank you very much, and noted, David. Go on.
Sorry, I do apologise, but your officer, and I don't wish to cause any disrespect, and we had this discussion only a week ago, there's a difference between commenting on fact and commenting on law. As a matter of, just coming back to the comments there, if I may, is that because a resident has said that they have received or being disturbed, it's not being witnessed by officers, so your officer was almost implying that it has quite a lot of weight because you have 6, but that the weight you attach will be a matter for you, of course. In relation to the statutory nuisance, I don't see it as a higher bar. Private and public nuisance, if it's one of those with subject to health, that the officer can serve it. And the issue is that if there is going to be a prosecution, then the premise licence holder is entitled to one, full disclosure, 2, raise a defence of due diligence or best practical means. And this is not the right forum to do it, although I understand that we will discuss it, but I just don't want the committee to determine innocence or guilt, potentially, of what is being said as an alleged crime, and it is alleged. Even though it's saying 6 breaches, they are being purported by the council as breaches, but they've not been established in the court of law.
Thank you, David. That's quite clear. Lorraine?
Yeah, sorry, I just wanted to make it clear that officers have witnessed statutory noise nuisance 5 times if you count the initial nuisance that the notice was served, and twice on noise monitoring equipment.
Okay, thank you. Right, are we all good? Let's...
Well, I'd like to just come back on just very quickly.
Yeah, okay, absolutely fine.
Just very quick, I don't want to go ping pong back. The DAT recording machines, or the machines that the council use, they can be manipulated. They're not witnessed by the officers, and you wouldn't prosecute based on a DAT recording machine. So I think we need to take that out. If you do, the local authority, if they choose to do that, it's quite difficult for them because they can have quite robust challenges. So all I'm saying is one has to be quite careful about that.
Thank you. Right, let's move on. Now it goes to interested party cases. Obviously, you've attended today. Would you like to say anything at all? If you just... Yeah, of course, by all means. Yeah, just let you say.
Can I read my statement?
Of course, by all means.
So, I am Natalie. I live at 114A Albert Road, which is the upstairs flat that is next door to the business. The noise in question from its mustard has been impacting my mental well-being since the 11th of February 2023, which is the date that I moved in. But I also lived in the property before 2018 to 2020 when the restaurant was a shop, so I'm well aware of the general noise of Albert Road in general, and then Southsea Sound as well. The noise in question that's bothering me a lot is live DJ music, as well as loud voices and shrieking in the smoking area during these live DJ music events. Sorry, I'm getting really shaky. These events...
We all do, trust me. It's not just you. Honestly, the other day,
expecting...
Emily was chairing one and she always threw up beforehand, so don't worry. Everybody gets nervous, don't worry.
Cool. These events, which are themed as bottomless brunches, have started as early as 1 o'clock in the afternoon and continued to as late as 12:30 the next day, with these times averaging to 3 o'clock to 11 p.m. The music can be heard throughout my flat in every room with the television on, windows shut, doors shut, and even carries through my headphones. The bass thumps and shakes throughout my property too. The smoking area noise can be heard in my bathroom, kitchen, and bedroom. These noises start loud and get louder throughout the evening. The impact of this noise is that there is nowhere I can be in my property to get away from it. The noise prevents me from sleeping and impacts my overall mental health. I get headaches, I am more stressed out, and at times I have been unable to get on with my activities the following day as a result of listening to incredibly jarring and repetitive beats for 8+ hours most weekends. I have gone to stay with my parents to get away from the noise and protect my well-being, but I cannot afford to do this every weekend because they live out of the city. I have also tried to plan my day around it, such as going to the gym at night, which as a young woman is unsafe in my opinion. I am unable to use my garden when these live music events are happening because there is too much noise, even with a set of headphones on. I cannot relax in my living room or bedroom, nor can I use my bath because of the sound vibrations. The noise first became apparent to me on the day that I moved into my property, which was the 11th of February 2023. I put it down as a one-off, but the same thing happened on the 25th of February. So on Sunday, the 26th of February, I went into the business to speak to the owner, which I believe is the gentleman here, to understand how often the noise was going to occur and to reach an agreement of things that he could do to help mitigate the noise. He was pretty rude, defensive, and told me essentially that there was nothing he could do, saying that he has to do what the customer wants and deflected blame to other venues on Albert Road, stating he had already soundproofed the bar. I used to live in this flat in 2018 to 2020 when the restaurant was a shop. I am aware of the typical noise of Albert Road, living near to the Wedge of Rooms and a recording studio. This new noise is excessive and the owner does not seem to care. Crucially, the owner told me that this event happens once a month, so I gave him the benefit of the doubt and didn't register a complaint with the council until later. After weeks of consecutive live events, it was clear that the once-a-month spiel that I was given was not the truth. I worked out that these events started in January from social media when there was no one living in my flat. On the 25th of March at 16:23, a day of yet more repetitive noise, I registered a complaint with the council. Since then, the noise has been an almost weekly occurrence with negative impacts to my mental well-being and an inability to relax or sleep anywhere in my flat. I do not see how anyone could put up living with such consistent noise pollution. It makes this property uninhabitable.
Thank you very much. Members, do you have any questions of the interested party? Stuart? No? Yeah, sure.
Natalie, thanks for coming along today to tell your side of the story. As far as you're aware, have either you or your landlord made any soundproofing modifications to the flat?
No.
And just for confirmation, you're living in the property above the post office on Albert Road?
Yes.
Yeah, okay. Do you know of any soundproofing modifications?
Sorry, just for clarity, is the post office directly next door? Because I'm not familiar with this. Okay, thank you.
And do you know of any soundproofing modifications that the owners of It's Mustard have made to their property?
No.
Okay, thank you.
Wonderful. Responsible authorities, have you got any questions at all of the interested party? No? No worries. And premises licence holder, do you have any questions of the...
No, I'll make submissions. I don't normally ask residents questions. So.
Good idea. Perfect. Wonderful. So we can move on. And now it's the premises licence to present their case, please. Thank you.
Yes, thank you, members. My client and the premise licence holder has been a bit concerned about how this matter has been approached by the Environmental Health Officer. It may be just the way the sort of the communication is broken down. Obviously, you and I won't be able to get to the bottom of that, but we're here today to look at promotion of the licensing objectives of public nuisance and public nuisance and not private nuisance. I will deal with this lady's representations in a moment in relation to next door. But generally, we can say that there's been a dispute from some of the neighbours at the rear. I'm not suggesting it's this lady at all, but there has been a dispute at the rear regarding car parking, and that the land owned at the rear is that of this premises. Oddly or not, but that's the reality of it, is the alleyway is only accessible by foot and not by motor vehicle, bless you, and that certain works have been done to take down certain walls so people now can park their cars at the rear, and they're not allowed to do that. That's caused the dispute since Mr. Stringer has been the landowner. The gentleman before had a sign up saying people don't have access. He was a more elderly gentleman who's passed away, sadly, and the premises were sold, and Mr. Stringer took steps to enforce, in effect, the restrictions that you can only cross over the land by foot, not motor vehicle. So a lot of the dispute has been driven by the landowner of a number of the premises nearby. I don't know, let me just check. So, and sorry, there's a bit
Sorry,
of
yeah,
discussion.
the question was just a point of clarity, David. The question is Councillor Brown was questioning the relevance of the parking situation with the solicitor and the solicitor.
Yeah, I can't see an issue
Yeah,
for
I
a bit
can't
of
see any.
background information.
Yeah,
Frank.
so continue, David, thank you.
Yes, the reason for raising that, councillor and councillors, is that there's a gentleman called Leighton Burns, who is the majority landowner by side of us. He has developed, and it's relevant because then you understand the motive for why some of the objections have come in. He is the landowner, and that he has his tenants, and we believe he has gone round to his tenants to try to drive objection to our business, because he has developed a number of flats at the rear that have now spaces for car parking, but they don't have a right to cross over our land, and also sometimes parking on our land. So that has driven, in effect, a lot of the objections, because there's actually a civil dispute between the landowner, even the landowner of the post office. So your landlord is in dispute with us, and it's all driven, we say, mainly by that. Now, of course, you'll be aware that your own officers have been in attendance and witnessed sound, so there is some evidence of matters arising. I'll cover that in a moment, but I want to try to sort of set the scene why there seems to be quite a lot of dispute towards the rear. And those residents are not here, even though they've written you're attached what weight accordingly. There is a case called East Gwent that makes it very clear that you have to have regard to them. However, what weight you attach is a matter for you. And Patterson licensing laws make it clear that actually you're likely to treat them with little or no weight because the maker of the statement is not present. And we're giving an explanation why there's quite a lot of residents to the rear that are raising objections, because in effect we've removed their right to park their vehicle at their flats that the landlord has developed without car parking rights to cross over our land. The property next door of the post office, where this lady resides, you're happy to address you as so in that way. So she is there, and I don't disbelieve that you are being disturbed by noise or unwanted noise. Now, whether that's a statutory nuisance or not is a matter of opinion, and that there's been some recording equipment that's been placed in the premises that have said it's not high enough for a statutory nuisance, and on another occasion it says it is. And what I'm saying, Chair, I have two positions in relation to this. First, I'm going to sort of suggest a practical way forward, and then the second, I'm going to, in effect, run a legal argument. But the practical way forward is we are agreeable to instructing a noise acoustic consultant, so that could be a condition. We're agreeable to a noise limiting device being installed and set in consultation with your environmental health officer. And there needs to be an exercise where that someone is in your flat, someone's in the premises, and they set it at a level that is agreeable to everyone. So, and those levels are different. So bass, they can set, the higher frequencies they can set. So they can set different levels to get it that hopefully everyone is satisfied, or if nothing else, you're satisfied. We'll just have to do more works to our building potentially to make it, we can do more, increase the volume. However, so we are prepared to do the noise exercise, Chair. The officer's opinion at first is that this is not suitable. In answer to your question, was tested by some question, following up question, and that proposition is not a correct one. The correct one is that the correct noise level will be when you do this exercise. The additional works that we are proposing by way of condition is to install the noise lobby door, another door at the rear, so that, and we've had a quote for doing that works. In fact, these suggestions come out of, I happened to be in Portsmouth recently, I did a visit, we talked through, and I've said, well, you may need a lobby door at the rear, you may need some additional works done to the glass, and that you need to set a noise limiting device with the local authority. So we work together. So those are, so there will be additional material going onto the glass that will reflect and help its soundproofing. So once those works are done, the noise limiting device can be recalibrated again. It may go up then, but for the time being, to give some respite, that can be done within the next 30 days, and when the works are done, it can be done again, so everyone finds the right level. We certainly...
If that's okay, take a question.
Sorry, can I ask what works that will be done to the glass? Do you know?
Well, I'll finish my submission and they can ask at the end, because I think it would
Sorry,
be
I
right.
thought it was a point of interest.
Yeah.
That's
Sorry.
absolutely, that's fine. We'll go to questions
Apologies.
at the end. Thank you.
So we say we will do that work, and ultimately it's somewhat academic what the value will be of that work, because ultimately we're saying we're prepared to set the noise limiting device on recorded music through the noise limiting device. Now, my legal submission is this, is that actually the dispute between us is really between the landowner next door and us as a landowner, because that landowner has got a commercial premises upstairs, got a flat, and that would be considered, that dispute would be considered a private nuisance. That's not a public nuisance. And the majority of the people at the rear complaining are all from the same landlord, and their dispute is about parking, not about noise. But if we look at the evidence of the council, when they've witnessed a statutory noise nuisance, in effect comes from the premises next door, unless I'm told otherwise. I don't think there's or if it's away, it's been rectified because there's been no further complaint since. So I think we need to take back a little bit, step back a bit, and just say, okay, we need to take some steps. Those steps need to be proportionate. It would be like a sledgehammer to crack a nut and just say, remove music, take away the business. That's not a proportionate and appropriate step to take. It's always a graduated approach. So the Natalie next door should be in effect dealing with her landlord to say, look, I'm renting from you, it's not suitable, you need to be dealing with the landlord next door, what works can we do between us, And we would have that discussion, because ultimately we have soundproofed our premises, and the flat above, it works. So it might be that we could agree certain works with the landlord. Obviously, he's got to have a discussion with us anyway, because he's allowing his tenants to use our alleyway at the rear. So therefore, there is going to be some discussions. And also, as I understand it, it's also dug up our road and put in services without our consent. So at the moment, there's probably 6 dwellings that would be inhabitable, because actually the services shouldn't be running through our land. So there's a lot of issues here. I can say that the landlord, we have made a complaint against the landlord that's subject to a police investigation. We won't say any more than that. And it was all captured on CCTV where the business owner was assaulted. So that's subject to a separate action. But can you have a look? If you look at page, let me just turn to it. Something very unusual has occurred, and I want to just point it out. There's no reflection on this lady here. I'm not saying it for this lady, because I think her rep's coming slightly different. But let me just actually get your representation. Excuse me 1 minute. 1 second. No, I'll get it. 1 minute. Yep. Excuse me 1 minute. 15. I'm taking it out 1 moment. Excuse me 1 moment. Yeah, so I can't comment on this lady's representation, but if you turn up to page 45, sir. As I said, something quite unusual's happened, and I think this gives weight to the argument that this is orchestrated by the landlord. Can you see the stamp? Received the 3rd of August. Now, can I ask you to turn up to page 47? The stamp, the 3rd of August. If you stand page 49, the stamp, the 3rd of August. The next representation, page 51, the stamp, 3rd of August. Page 53, the stamp, 3rd of August. Page 55, the stamp, the 3rd of August.
I think, David, we're going to have to get an answer from the licensing manager of why that might be, if that's okay with you. I think that's, yeah.
I take the point, but it's not unusual that residents will...
No, that's a different point. He can have I'm making my submission. If he wants to clarify whether there's validity to the stamp. But he shouldn't be making representation. I'm making mine, unless I've said something factually incorrect. But I don't want him having an opinion. He doesn't have an opinion because he's not a party to the proceedings. So no disrespect to the officer.
I was only going to explain how that would happen, but I'll wait till later if that helps.
Yes, we will come back to that because I do want to hear that. But carry on, David, please.
Yeah, I'm not being rude to the officer. I'm just saying we've got to be careful that the licensing authority have not made a representation. And if, for example, the licensing officer says that they were all held up and they were just grouped together and then stamped on the same day, that you need to know. But
I mean, let's see what he says in a bit. I think if you're going to try and use that as us to add weight to it for your defence, I think it's only fair that the licensing authority gives us a clear reason of why.
Okay. And do you know what, Chair? That I'm happy with, but what I'm not happy with is drawing some assumptions, or it's not.
You just
unusual.
want it factual.
Yeah,
absolutely fine. We'll go to that after.
And the reason I'm raising this, Chair, is that I want to carry on with my submission. So the 56, the 3rd of August, page 59, the 3rd of August, page 61, 3rd of August, page 63, 3rd of August, page 65, 3rd of August. Now, I want to make it absolutely clear that gives weight to our representation that this has been orchestrated coming in together. Now, it might be that the landlord has gone around collecting these letters saying, I want the letters of objection. It could be the landlord said, oh, let me help you, whatever it may be. But it is unusual, yes, for disparate groups of individuals to write in exactly on the same day. You and I know a petition, yes. We've dealt with Monty's Bar recently, where that people gather together. That's not a problem. But letters come in at different dates and times. For them all to be in at the same time, the same stamp, I say gives weight to what we're saying is that there's been a orchestration. The representations has been solicited by another, and the makers of these statements are not here. They're not here. Yeah, and I think it gives us weight to the point is, which I sent over last week, that there is a dispute about parking at the rear between the landlord.
Can I see
us.
whatever that document is, please? Have I got this document?
I think we did ask for it to be circulated, but so sorry, I thought they'd already been circulated like the
No,
other
no.
document. Could I, Councillor, are you able to help? That's very kind. Thank you. Thank you. That's very kind. Does anyone have any objections to me referring to it?
I certainly have no objections to us referring to it. Members don't. Responsible authorities, do you have any objections to us referring to this plan?
I have no objections, but I don't really see the relevance in relation to the
No worries. Continue, David. Thank you.
Just to clarify, Chair, because I was discussing it with the licensing officer, just to clarify that I asked if it had been submitted in advance of the hearing, and that's all that we were discussing.
No, that's fine. Thank you. And I believe the answer to that would have been yes. Thank you very much for that, sir. So, Chairman and members, you'll see that this bit here is our property. The land at the back is the alleyway. All in red, lined, is our land. But what's happened is that the main objectors are here, in this area, where there's been building of 6 flats and the commercial accommodation. And this quadrant is where really all the complaints have come from, and that's the same landlord. And in essence, we've come into dispute because what's happened is that there's been a boundary wall taken down here, and cars are now coming and parking on this land, coming over our land, and we've got garages here and workshops, and it's being blocked. And we're saying actually you have no access. Now, you've heard from Environmental Health that she doesn't believe that's relevant, but our submission is that gives reason and motive why we've had a high number of objections from the rear and our neighbours, notwithstanding the comments that you've made about the transference of bass or noise through. And what we're saying is I've offered a practical solution on how we address that, notwithstanding I believe it's a legal point that dispute between them is a private nuisance, not a public nuisance. And a public nuisance would be a widespread of Majesty's subjects, and it wouldn't be reasonable to expect one person to take an action in their own right. But you have to bear in mind that the majority of the complainants, I think the complainants that the Environmental Health has alluded to, the 4 complainants in the grid that we've been provided to, and maybe she can clarify, but I think that you'll find that all the complainants are within this grid. Sorry, I do apologise. The main complainants will be within this grid, being the same landlord. But if it's not, maybe the officer can identify not the individual home, but where roughly it is. Because obviously I think that will bring relevance. Because I've got it 730 is the lady next door. 734 I don't know. 307 and 315. But there are only in effect 4 complainants in the immediate vicinity. We are trying to assess and making some assumptions. We may be wrong, but at least we raise it now, and it's something that you can take into account.
Would you like me to clarify that now?
No, you can do that later.
Okay.
It's fine. Yes. So what I would say is that we will perhaps deal with that in our summing up. One moment. Sorry, I'm just being told that we did get all the names and addresses of everyone, and in fact they got the home address of us, and obviously that was subject to the licensing authority breach of data protection, and that was addressed by it being withdrawn, I think, from the public domain, because obviously the home addresses and personal details were disclosed on the public register or the council's website. So what we're doing is we're saying, look, we are a new business. We are trying to work with the council. We are having a bit of a difficult time, particularly with this officer, because we feel the initial starting off didn't go as well as it could do. We say that she was disruptive. She did storm out of the premises in the way that we described earlier, even though there's a difference of opinion. And we say, in correspondence since and now, or certainly by email, and I think even on one occasion on the telephone, we were read our rights. And that's not really conducive to a working relationship. Every time you meet someone, you have the right to remain silent. If you do not say anything now you wish to, when you start going into that before you even say good morning, hello, how are you, I think that's a difficult relationship. And I think a practical way forward is for you as members to see through that and say, okay, how do we go forward in a proportionate, appropriate step? We think most of the complaints come from the rear. We believe a new lobby door to the rear will work that out. Acoustic film on the glass, a noise limiting device, and we are proposing to close the outside garden area, except for the use of the toilets, from 9:30 in the evening. And we think that that is a proportionate step of measures to achieve the licensing objectives as a graduated approach. And we do want to work with the council, maybe by having this review, we're stepping back a little bit. Members, be aware, since the 11th of July and now, there's been no other complaint other than the lady next door. Other than that, there's been no complaint since almost the beginning of July. So July, July and August, so we're into September now. So 8-9 weeks. Through the whole summer, there's only been one complainant. And we think that we can maybe address that by doing these additional works. We ask you to act proportionately and appropriately. I've got the details of the acoustic glass and works that we're going to do. But if there are questions of me of that, I'm able to answer. Unless I can assist you further, those are the submissions on behalf of the premise licence holder.
Thank you, David. I think first of all, as well, what might be nice is get an idea about the business, because I'm not personally familiar with its mustard. And when it come forward, I was told it was a beautiful roast dinner place. So I was a bit confused where the club kind of music come into it, because I never heard of it, and I said, oh, it's mustard's up for review. Oh, it's an amazing roast dinner place. And I'm like, oh, okay, that's strange. Could you just tell us a bit about the business, please?
Yes, well, that's good you asked, because in fact there are we've had letters of support. Unfortunately, you've got some in the pack, and others have only just been coming in, so it would be unfair to bring them to your attention now. But we have had a lot of support from the community. It's a very small premises. The capacity is around 60-70 people, so it's not particularly large. We've spent nearly £300,000 refurbing, refitting, and actually the council, when we did the premises, the local authority insisted that we did soundproofing for the flat above, which we did. So that's why obviously we occupy upstairs, but we know what that's like. So it's a relaxing environment, well refurbished. Yes, on a Sunday we do a great Sunday roast. Unfortunately, because of the points delay coming out of London, I missed my Sunday roast yesterday, but maybe another time. So on a Sunday they do that. They do food during the week. and we do provide recorded music, and occasionally we provide a DJ music and some live music, but we're happy to run that through a noise limiting device and to install a noise lobby door. So it is a premises where that you can come. I was told last week that a lot of people come because it's not so noisy, they do good food, and it's somewhere that you can feel safe and not intimidated in any way. So it's a really good environment. Now, of course, we generate noise, and if the fabric of the building and next door is not soundproof or works have not been done appropriately, then clearly we have an issue directly with our neighbour because of that private nuisance. But outside of that, really, we shouldn't be affecting anyone else. And we generally believe that the complaints from the rear come really about because of the civil dispute of the parking. But notwithstanding that, we do propose additional measures. So, unless Joe, do you want to just summarise any more of what I've said about the premises? Are you happy with that? Thank you.
I'm sure you'll get your roast dinner, David, soon. So obviously that's a bit about the business. I'm just going back to the reps because obviously you made the point that all the reps come in on the 3rd of August, and obviously you said that's suspicious. But I couldn't help but notice between page 31 and 44, where obviously it's supporting reps. Likewise, every email is coming on the 8th of August, all within the same time frame of 2 hours, all saying roughly the same thing.
Yeah,
so,
no, we did solicit support. So we've gone out to get support and asked people to write in. So we can clearly say that, and you'll treat the await appropriately. But
okay, that's fine. Do you currently have a noise management policy in place? And if not, would you be willing to attach that to conditions should it be relevant, and obviously just give that to local residents?
Yes, we don't have one. Obviously, at the moment we're sort of it's somewhat ad hoc insofar as we are trying to monitor it. We're going outside measuring or listening. We're closing the garden a bit earlier. So we are taking some steps, and we've been doing that since the review. And I think that is demonstrated by the fact that we've only now got one complainant since July and now.
Okay. So the business model, do you rely on live entertainment to keep the business running? And I guess the secondary supplementary question to that is how many live music events do you have per week, per month? I mean, obviously we know how many complaints we've received, but how many times have you had live music there's no complaints and stuff? So how many?
Yes, thank you for that. Look, we, like any business, require music. I mean, where have you gone to have your Sunday roast or your food and you've got no music? So that's one style of operation. The other is that if you go to a bar, you want music to be entertained. And we're not open late. Music is off by 11. Look at the complaints. I mean, most of them, obviously notwithstanding this lady saying that she's experiencing difficulties throughout the day because of probably more the structure of the business, the structure of the buildings and the proximity to each other. But outside of that a lot of the complaints that I noted, 7:30, 6:30, 10 o'clock, 10 to 9, they're not particularly late. We believe that we obviously need music. Generally, DJs were using or have been using no more than probably about 30 hours a month, but obviously in the evenings on the weekends we're using. But I don't want to tie our hands down to saying, well, only one event a week, or recorded music we have all the time, and we're happy to run that through the noise limiter. And we would say most weekends we would like to have some form or put on some form of entertainment. But as I say, we have done that through August without any issues, and July without any issues to the wider public, except for the private nuisance of the neighbour next door. Other than that, we're not disturbing anyone. We put on a DJ in July and in August. I mean, if you lived next door to that bell, you'd probably get used to it. But if that was going through the night and that was going on, you'd say, well, that's an unwanted noise. The train line now going through unwanted noise. If you live what is classed as the nighttime economy, that road, I mean, I've walked down there, that is really busy. Yeah, you move to a flat in that area, above a commercial premises, next to commercial premises, notwithstanding previously occupying the flat some time ago. The reality of it is you are going to get a certain level of noise during the day. Now, I'm not suggesting that you should accept the level that you are at the moment because of the fabric of the building, but generally those flats should be constructed in a way that should allow or protect you from some of those noises, because you open your window, you're going to hear the noise from the Redwood rooms across the way. Behind we've got a sound studio. So
I just want to bring it back a little bit, only because
Okay.
obviously I was asking about the things, if that's all right. Simple question, really. Why didn't you appeal the noise abatement notice?
they got too late. They wanted to, and so when if the local authority prosecute, we will be defending them.
No worries. Members to my left, Stuart.
Thank you. During the representations we had from Lorraine earlier on, there was some hint that there might have been a noise limiting device or some sort of noise monitoring device installed. Can I just check, as of right now, is there any form of noise limiting or noise monitoring device installed at the premises?
Yes, there's some devices on the speakers. The officer says that's not satisfactory. They've had additional unit installed, delivered, waiting to be installed. My advice, not to get into privilege, but my advice is that they should get an acoustic engineer, acoustic consultant to recommend the right device, right zonings, and at the moment, since COVID and now, there's been a rise in complaints between residents and businesses, and generally it can be resolved by doing a report, going into the nearest sensitive receptor, installing a noise limiting device, fitting lobbies, doing other works. And I think we should take a step back, start that process. You can put it on as a conditions, and we would happily start working in that way.
So the devices that are installed on the speakers, are they set to a certain level of decibels or a certain frequency output? How do they work?
Right, sorry. I think there's been a number of actions taken to try to resolve some of the issues. So they've got the speakers are adjusted or monitored by each one being controlled. So that's a form of restricting. In relation to the speakers, Joe's just telling me that when they have the extractor fan on in the kitchen, they turn the speakers closest to that area so that the noise is not going through the extractor. So that's just being practical, and so it doesn't go into the latest flat. And what they do is they go outside the front on the pavement and at the back, and they've got a handheld device that monitors dBA, and they make sure that it doesn't go above 84 dBA so that the noise is within. And I think that's probably the first time I've heard of it, but it's probably right, because normally and I'm sure your own expert will tell you, but generally from outside to in is a reduction of 15 dBA. So that would bring it below 35. And the World Health Organization, certainly in relation to sleep, says that it should be below the 35 dBA from 11 o'clock PM for sleep. But we're talking about during the day. So the ambient noise outside is going to be higher than 48 dBA in a commercial area. At the back, it will be reduced without a shadow of a doubt. So they're doing a number of things to try to regulate it. But as I say, sir, that I think the main council, the main thing will be is to get an expert in. The expert can then work with the council so that it helps with the relationship, and then try to take certain steps. Clearly, there is a particular sensitivity around this lady's dwelling, a flat, and trying to deal with that particular problem. And then outside of that, it looks like what they're doing at the moment is working, because there's been no complaints in July and August. Whether it's satisfactory as a model, because it's arbitrary, it gives some doubt. A lot of these can be controlled and managed through devices, so they're set. There can be no manipulation. There's no guesswork. Everyone's working, setting it at a certain level, and everyone should be satisfied.
Yeah. Thank you very much indeed. Thank you.
Emily, any questions?
Yeah, when was the glass roof done? Was that previous before you took it over, or something new?
No, it's something new. We've put it in. It actually looks really nice, but obviously I don't know its acoustic value. But we are prepared to put the film on it, and we're prepared towards the back end of the building. There is an area where you could fit another door quite comfortably, so that will at least protect the residents at the back, which will probably be the most sensitive in the sense of the noise at the front. It generates a lot of noise. At the back it will be less. But we still believe at the back we're probably not causing that level of noise, but we'll install the noise limiter so that addresses that. And we have put signs out saying please respect neighbours in the courtyard, and we are closing that area off for consumption and smoking from 9:30. But you have to go through there to go to the toilets, so we can't close it off completely. So that's why we want to put the lobby door, so that if there is any music, that should stop the leakage or any noise escape through the lobby door. And we only have a capacity 60-70 anyhow.
Fine. Did they know that they were going to do live music before they built this?
Yes, I think we intended to do music, certainly. Before it was crystal glass, just single glass. So it is a double glazed structure. It's not some flimsy. It's quite substantial. But we're just trying to add to it rather than going to triple glaze. We've been told by the glass company or someone that can advise us that we can put certain material on it that helps its acoustic value. But in any event, can I just say this? It doesn't matter what we do, the work, the noise limiter will set it at the appropriate level. So it might be that it's not the level we want, but ultimately it safeguards everyone else, and we'll have to do more work if we want to increase the volume. And we're prepared to work on that basis.
Typically when you have a DJ, how long do they play for, and do they have breaks? It's only because someone mentioned 9 hours, so I just want to know how long they actually play for.
Yes, it's like a piece of string. It depends on the event, I'm afraid. So sometimes in June it was roughly 4 hours per set. That was it. And that was it in June, only one in June. And in July, generally, it can be between 4 and 6 hours. So, but once again, not repetition, that will be going through a noise limiting device.
Just got a few follow-ups. This might sound random. Has the venue got a carpet, or is it floorboards?
Upstairs?
No, in the venue itself.
Oh, the venue? No, it's just wood and resin. So, yeah, so it's just wooden.
Okay, wonderful. So obviously you received the noise abatement notice, missed the appeal, and I'm sure you're going through a process now. Obviously, the 11th of July, you were given given the notice that there was an intention of a review today. After giving the noise abatement notice, why did you continue to do events? What was the reasoning behind that?
Well, it is a premises that generates noise. It is a licensed premises, but we believe that we are putting in best practical means, and therefore can demonstrate best practical means, and believe we have a defence. So it's unusual for a local authority to issue I don't think I've ever seen it actually. Normally you issue one noise abatement and then you may prosecute against that. You may issue a second one because perhaps you got the parties wrong. But to issue 4, I've not seen that before. But in any event, that's a matter for the local authority. All I would say is that I've now advised that in relation to the noise abatement, if there is a prosecution, then obviously we will raise our defence at the time. But look, we don't sit back, and we haven't just sat back and said no. Jo is very conscientious. She's come here worried, sick about being here, what's going on, her job, the workers, the customers. She also wants to make sure that the lady next door, getting that balance. But obviously we've fallen out with the landlord, or the landlord's fallen out with us, actually assaulted the premise licence holder. That is not conducive to trying to develop a relationship, to try to say, okay, where are we, what are we doing?
And final question from me, in relation to obviously the things you put forward. Would you be happy to not do events until these things have been implemented?
No, but what we could do is certainly not do any live music until the works are done. I think we could probably restrict that somewhat, or say it's only once a week. But in relation to recorded music, we want that all the time. But clearly, we will manage that as we have through July and August, which is our busiest time, without complaint, except from the lady next door. So unfortunately, that's going to require a little bit more work, but we'll work with the officers. We have been turning the volume down. If we can try to work with that. So your decision, as you know, doesn't have effect for 21 days. If it's appealed, may not have effect for 6 months to a year. We're not going to hang around. We've already started to do the steps that we need to get the noise limiting device. We've got the quotes, and we're looking to try to start work very soon on the lobby door. We're quite happy to work with this lady. Maybe if now she's seen Jo, maybe they can have a conversation about how we can work better together. So we'll certainly want to work with each other. But I think to say no regulated entertainment would be a step too far, and I don't think it would be fair.
Thank you, David. I don't think members, any other questions?
Yeah, just one quick follow-up.
Go for it, sure.
So obviously it seems now that you're very keen to engage with the process, find a balance that works, which is fantastic. Obviously with the one noise abatement that had 6 notices of breach letters following up, why was there no response to the letters?
Because Jo was scared because of the continual caution. She thought she was under arrest, so she was a bit frightened about the approach, and I've explained how we can deal with that. So I think it felt somewhat the relationship had soured, felt intimidated, and felt that she's being arrested. Bless you. I hope there's nothing catching in the room. So I think yes, you're sitting closer. But I think the point is that now I've been instructed. Yes, now I've been instructed and trying to help. I think we might be able to make some progress going forward. That's what we wish for.
I am assuming that the responsible authorities will have questions. Is that correct? So, bearing in mind it's 12 o'clock, I'm going to call an adjournment for a comfort break for 15 minutes. So, if anybody would like a cigarette or use the toilet, we'll have 15 minutes and we'll return here at 12:15. Thank you. Hello, welcome back to the subcommittee hearing for It's Mustard on Monday the 7th of September. The time is 18 minutes 4th of September. Almost lost a week of my life. It is 18 minutes past 12. So we're currently on the premises licence holder's case, and we adjourned during the end of members' questions. Have members got any further questions, or are we done?
Actually, yeah, do you mind if I...
Yeah, if you've got, yep, quickly, yep.
Yeah, I'll try and be as quick as I can. Obviously, questions for Mr. Dad's related to the management of the venue, so this might relate to your client. Just to double check, the DPS is Joanne sitting to your left, is that right?
Yes.
Yep. And do you mind if I ask, how long has Joanne held her DPS, her personal licence for?
Oh, for many years. About 14. She's very well experienced as a licensee.
Mm-hmm.
So she's managed premises, football premises, premises dealing with different crowds. So she's more than competent to deal with this premises, being the capacity it is, etc. She has struggled somewhat, and she was telling me outside, and quite emotional about it, struggled with dealing with how the officer has approached. Now, it might be just a misunderstanding, and I've spoken to the officer, and I think it might be just a misunderstanding, but she was going on a holiday. She said, just about board the plane, received an email with a caution. She thought she'd been arrested. She went on holiday, panicked that she was being arrested. So I think while she's very experienced at dealing with customers, dealing with that, I think this process is very new to her, and I think we need to just take a step back and say, okay, how do we help each other out? Because she's a good person, your officer's a good person, there's been some breakdown, we need to fix that.
And in her role as a DPS for previous venues, has she had any interaction with either Portsmouth or other licensing authorities?
It's all Portsmouth, I understand.
All Portsmouth, yeah. But she has had interactions with the council as a DPS prior to this?
So, yeah, she's had interaction with responsible authorities and officers, nothing negative but positive. So she has had a positive relationship with the authority and responsible authorities.
Super, thank you.
Wonderful. So we are now going on to interested parties first of all. So Natalie, do you have any questions at all of the premises licence holder? No, no worries at all. And now we're on to responsible authorities. Do you have any questions of the licence holder at all?
I've just got one for clarity, if I may, please. David, you've given us 2 times. I don't know if you're aware of that.
But
You said that you closed the rear garden at 9 p.m. and then later on you said it at 9:30. Which one is it, please?
right. Firstly, I've got a technical point. I'm happy to answer it's 9:30, but I've got a technical point. I believe I should only be receiving questions from those who have made representations. I don't know if this officer's made any representations in 28 days.
Ben?
Technically, the licensing authority is not a party to the hearing. It's your discretion, Chair, whether you want to allow questions via yourself, really, frankly.
No, we'll move on. Lorraine?
Okay, thank you. Just need to clarify some points, if that's okay. Sure. So, in relation to the noise abatement notices, only 2 noise abatement notices have been served. One on Miss Joanne Johnson and one on It's Mustard Limited.
Oh, thank you for that clarification. I've got it as 4, but I don't know how that is. It might be that they're just duplicate. Thank you.
Okay. In relation to another clarification, in relation to the location of the residence, there are 2 attached, 1 at the rear and 1 on Albert Road.
2 attached, 1 at the rear.
Well, yeah, as attached into because it's flats, do you know, like it runs above the residential.
Sorry, so 2 within in the block, 1 at the rear, and 1 at the front.
Yeah.
Thank you. I know I'm answering your questions. I'm now asking you a question. I'm sorry. Is it possible on the grid? It might help all of us. So through you, Chair, if I can just if we can identify the ones like 730 we know is attached, one of those attached, if we could just go through that.
Yeah, if we've got the information and it's okay with our legal services, I would like that. If you've got it, if you haven't,
I can have a rough guess because obviously all the complainant's details have been blanked out. So I believe I can clarify it at a later date or later on today if you want me to. Is 734 Albert Road, I believe. 730 attached. And I can't clarify with the other two because there's no name that I know from the name. So
that's okay. But thank you. Continue, Lorraine. Any questions?
yeah, sorry. Another further clarification in relation to the caution. This is part of our procedure if we are considering any formal action. So this was probably first sent in an email with one of the breach of abatement notices. So that's just for clarification.
Yes, thank you. So to answer that question is that whilst I accept that that might be part of the process, when you are trying to take a graduated approach to enforcement and try to do informal as well as formal action, sometimes in each and every communication we found it that we've not been able to move forward. So it might be something that councillors, through policy making and policy decision making, it may have an enforcement committee, I don't know, or a regulatory committee at the city, that maybe they can have a look and make some policies around that. Obviously from practice, operational, that's not for councillors, I understand that, but certainly from a policy point of view, councillors, I would say that, you know, if you're trying to work with officers through like a graduated approach, you can't be cautioning everyone every time, because otherwise that relationship could break down, and there could be some real benefits. As I said, look at the hours that have been spent on this, doing the review and all that concern, whereas actually it might have been resolved by an informal having a discussion and try to resolve it that way. Many less hours and to have got to the solution much quicker.
Any further questions?
Yeah. Sorry, can you just clarify if a noise limiter is actually in place now?
No, we have the noise limiter, but it's not been installed and set. That can't be done until acoustic engineer. We want to have a discussion with you on how we should approach that, and we thought we'll wait for the hearing today as well. So we'll work together. But what is in place is the handheld device going out, monitoring that externally at the front and the rear is not above 48 dBA.
Okay. Can I go back to that noise monitoring that you're using then? So first of all, where does the noise limit 84 dB come from?
Yeah, it's just a figure that was been given to the
Sorry,
premise licenser.
84.
Is it
Sorry,
84?
48.
I think
Sorry,
there's a big
48.
difference. Yeah,
Yeah,
okay,
yeah,
48.
sorry.
No worries.
Yeah,
it's fine.
48.
Yeah,
Did I
sorry.
say 84?
Yeah, you said
Oh yeah, sorry, I do apologise.
Yeah,
I
yeah.
transposed the numbers. Yeah, that would be a bit noisy outside. So 48.
So where does that come from?
I understand that that's advice that's been given before. I don't want to get into that, but we've been given that. But outside, 84, and actually
84.
48. Well, okay, it must be something with those numbers. I apologise. So I'm going to write it down. So it's not a Freudian slip, I can tell you, because you would hear it outside. So certainly answering the question, and it might be that the officers can respond later, but certainly normally when I've dealt with cases before, music outside going in, there's normally a difference of 15 dBA thereabouts. But obviously, if the officer believes that 48 is not a figure that they recognise as being suitable, then obviously they can give us the appropriate advice. But I would have thought the background noises at the front would be certainly much higher than that. At the rear, may not. I don't know.
Sorry, going back to the noise limiting device that you've got, or sorry, you monitor. Does it have frequency analysis on it?
I think it's just a noise limiter, so it won't be, noise measuring monitor. And so I know that certain devices, you and I have seen them, where you can do it over a period of time and it will give you an average of the LEQs. I think they're just using it rudimentarily just to try to ascertain what is an acceptable level. They're doing their best. And I think you will agree with me that since July and August doing those steps, they've had no further complaint from anyone other than the adjoining building.
Okay, sorry, I keep going back to the noise monitor. So obviously if it's just monitoring LEQ levels, it won't pick up any bass frequency, and that's what we've found being an issue.
Yes, I hear what you say. What it is that I hope you're hearing what I'm saying, is that from July and August, there's only been one complainant, which is the adjoining premises, which you say is the low frequencies through the base, which I say is more of a private nuisance than the public, because there's no wider public complaining. So that is working because it's knocked out the other complaints. The complaint between next door and us might be something more about the fabric of the building. It might be they don't have carpets, they have wooden floors. It might be other ways of transferring, I don't know. But certainly from outside externally monitoring, it is working because there's been no further complaints in July and August, we say.
Okay. I'll just make a comment in that, have you got any records to show that monitoring's been carried out?
Yeah, we do keep a record, thank you.
Okay. Going back to the base levels and it penetrating the structure, I've got a couple of questions in relation to that. One is in relation to the glazing film that you said that you're going to install. Do you know what the noise reduction level is for that? And is that just LAEQ?
No, I can't answer those technical questions, but what we're saying is it'll be a package of measures. We're going to engage an acoustic consultant. The lobby door will assist, the film will assist, the noise limiting device will assist by setting the different levels that you talk about.
Okay, and also going back to the structural works, would your client be happy to take any further works to reduce the structural transmission of the base?
We will, with the acoustic consultant, have a look at it. I think it may be that some work might be needed to be done in this lady's property, which would need to have an open discussion with the landlord about that next door. And it might be that we need to look at whether, when the flat was refurbished, whether it was done to the proper building regulation standards, because obviously that might be a problem. So what we're saying is that if there are some works that we can do, if there is some work that we can do working with the neighbour, and they're reasonable works, we will look at that. We won't rule it out, because ultimately it's out to our benefit. We need to be neighbourly, we need to work with each other. Obviously it's a private nuisance, a private matter, but if we can resolve it, it will help us both. So if your landlord, or if, will allow you to have us access, have a look with the noise acoustic consultant to see where the noise escape is coming from or where it's coming from. It could be something very simple. I've had it before, Chair, just so that you know, I've had it before where the two beams have crossed and it's been transference, and then something's been done to those beams, which means it no longer transfers. It can be something very simple like that. So until you investigate, you don't know how it's transferring. But we will certainly work with next door to see if we can identify that transfer.
Sorry.
I was just going to add some clarification on the structural transmission, just add a little bit to what you said, just to make yourselves aware, really. Mostly when it's structural transition, it's vibrations through the building, so there's lots of different things that might be able to be undertaken and aren't necessarily huge structural issues. But obviously with a consultant, they'll be able to identify, how their equipment is mounted.
Yeah, I mean, we know carpet helps, rubber helps on doors and so on and so forth.
Removing certain speakers or putting them off the floor. Yeah. We're happy to work with the council, take a step back and work, because obviously this lady needs to be able to rub along, get along. We need to get along, and hopefully we can try to find a solution.
Any
Sorry,
further questions?
yeah, just one more.
Keep going, Lorraine. I'm enjoying myself.
Just another question is, why wasn't another appointment arranged earlier on before the other breaches were witnessed in relation to setting noise levels?
I'm not going to continue on the same line. I think that there's been a breakdown in communication between us. I've been a little bit critical of your approach. You may be critical of our approach, but hopefully today we can draw a line. There's been some misunderstanding, poor communication. It may be that this exercise allows us to take a step back and move forward in a positive way.
Okay, just one more question about the speakers. So, how do you control how are the levels being controlled on the speakers? Because obviously, we have had further breaches. So whatever's been done has not made any difference.
Well, you've had 75% of your complainants no longer complaining. So you've got only one complaint from July, the 11th of July now. So there has been that improvement. We need you to recognise that and be a bit more positive about it. It doesn't completely address it, but it's a positive step. And if you can accept that that's positive and we can work together to try to find the solution, see if we can find steps forward for this lady, then that works, doesn't it? That's good for everyone.
I mean, there has been complaints, and there is still obviously ongoing complaints because there's been 15 representations been made.
Well, you've heard my submission. Some of them are motivated by different reasons. I'm not going to reiterate myself, but from the application till now, there's only been one complainant, and none of those individuals have complained during that time of the representation to your service. There's only been one complainant, and we think they're driven by different motives. So, look, I don't think it helps us to re-go over that.
Wonderful. Responsible authorities, are we finished on the questions? Yeah, no worries. I've just got a point of clarification, please, Mr. Dadds, if you don't mind. Obviously, Joe is the DPS. Is it Andrew? Sorry, Adam. So obviously, Adam is the owner. Is that correct? Wonderful. And so, what's Adam's role in the business? Is it a proactive, on-site approach where you work, or is it more of an ownership kind of approach?
No, it's Joe is in effect the licensee. She runs it for Adam. Adam doesn't work as the licensee. He obviously does pop in. He is financing the business. He's hoping to make returns, but from his point of view, he doesn't become involved. So let me just explain why I'm asking, and it's just to see whether Adam himself, did you have any communications with our regulatory authorities? Has it all been with Joe? Have we approached you as a council and tried to deal with the owner, or has it just always been through the licence holder? Yeah, I think it's been both, actually. So it has been both. And as I say, there may just be a misunderstanding between both, because actually, and dealing with Adam and Joe, and only on the few times I've met them in the last month, they genuinely want to work with the officers. I know that Joe has a good, positive working relationship with your licensing officer, even though I keep on stopping him speaking, but that's just process, I'm afraid. That's what I'm here to do process. But they do have a positive relationship, and they know of each other. So that should be able to bring some goodwill to say, look, this is where we are, this is where we're at, and we want to work together. Thank you, Mr. Dadds. It's a shame our licensing manager can't speak, otherwise he could give a nice character reference. So you've said Mr. Dadds now. You used to say David. Oh, I'll keep it at David. There you go. I believe our city solicitor has a few questions. Ben.
Just really a couple of questions. Yes. The first question is, and I apologise if it's in the papers somewhere and I've not picked up on it. Is there a sort of a suite of conditions that are proposed by the premises licence at all that have been worked out? You haven't missed it, because I was only here last week and I sort of went through it with them. But so I have suggested a condition regarding the lobby door to the rear, acoustic film on the glazing,
um, the sound limiting device, but also the instruction of a noise acoustic engineer to give some advice and recommendations. So there are, in effect...
And we've got closure of the smoking area as well.
Yeah, so-
I've got from 9:30
Yes,
p.m.
we do that from 9:30. We also have signs out there asking people to be respectful for our neighbours. The area is not closed for ingress and egress to the toilets, so it's only open for ingress and egress to the toilets. Other than that, and there's a fire exit, but other than that, the outside area is not used. And that's why we're proposing the lobby door, so that after 9:30 it stops the noise escape, or if there is any. I think that covers everything, sir.
Yes, I just wanted to be clear so that obviously when advising the subcommittee when they retire. The other point was a technical, and you may not have the answer off the top of your head, but you referred to Patterson's in particular, making reference to a point about those residents not being present today and their evidence not being capable of being tested because they're not present. But I've got Patterson's electronically and I can't seem to find it, so I was just wondering if you possibly knew where that might be. Or...
Yeah, if you've got it electronically, I can maybe, when we finish the break, it is normally around human rights and the point of a fair hearing. So I know exactly where it is, but it's East Gwent case, and it says that that is a case where the licensing justice rejected representations on those that weren't present. The High Court said, no, you have to have regard to them, but it's in effect what weight you attach. The point about weight has not been addressed, but Jeremy Phillips, KC, says his opinion is that they should have little or no weight, given that the maker of the statement is not present.
Thank you. I think that broadly confers with my advice. Certainly the first stance that you placed is as far as the subcommittee has to take them into consideration. They are relevant representations, and it is a matter of weight that you wish to attach, and that's going to be a matter of fact in each case.
Any further questions, Ben?
No, not at this stage. Thank you, Chair.
No worries. So before we go to summing up, I do something unconventional, but I like to do it just in case. So does anybody in this room want to say anything they've not said yet, or anything else that wants to be opened up? I like to know that all the boxes have been ticked by everybody, so no one can go away and say, I didn't have the chance to say this. So is there anybody in this room that's got anything left to say before we go to summing up? Beautiful. That's what I like. So
It's a very interesting point and approach. Last time someone asked me that question, I said I would go at the end once I get to
but right now you're all good. Okay, cool. So yeah, we're going to obviously go to sum it up. So first of all, we'll start with the licensing authority, please.
I have nothing further.
Thank you very much, Derek. Lorraine.
Yeah, I just want to reiterate that that given regards to the fact it's clear that the premise licence holder has failed to act on advice from the local authority and have failed to comply with the public protection of the premise licence and the licensing guidance, I therefore wish you to consider the provisions of 17C of the Licensing Act relating to the live music and recorded music, so it no longer is applying in respect to this licence, and the provision of regulated entertainment consisting of performance or live music shall be excluded as a licensable activity under this licence.
Thank you very much, Lorraine. Natalie, this is your chance now to say anything you want to say to sum up. Any last words before we go to decision? Absolutely fine, no worries. Thank you very much. And David, your final words,
Yes.
please, sir.
It will only be about 30 minutes. No, I'm only joking. So just a quick look. I don't want to sort of be combative with the licensing officer. The environmental health officer. You know, the comments on the summing are not accepted. she will be aware of the facts that we have when we know that from the review until now, there's only been one complaint and there's been an improvement. So that is positive to say that there's been no taking of advice. And also you've heard about the difficulty in the communication, and I'm not going to repeat it, but there has been some. And when I look at the log that's been very useful, and thank you very much for producing it, the summary, I can see in May there was only one one complainant, which was the 730, and then in June there were in effect 3 complainants, but only one complaint from 734 and one from 315. And in July, I say there were a number of complaints before the review, and then once the review is brought, I've just said only one complainant. It's lies, damn lies and statistics. It depends on how you want to approach it. But I think the reality of it is that we know that this is a licensed premises that will generate noise, will generate music, has to generate music because it's a licensed premises. It's in a commercial area. It is in an entertainment zone, a road, a late night economy. And we know we've had some complaints that are happening in the afternoon and early evening. But those complaints are logged, and certainly from May till now, you've got them in front of you, what they are. We say there are some other explanations of why we've got 12 or 15 different complainants, because we have stopped or attempting to stop unauthorised access to the lane, which has been which we say the landowner has been driving representations. I think that is an important point. Notwithstanding, officers of your council are separate from that, and they wouldn't raise an objection based on car parking on the road. But I think there's been a bit of a falling out in the approach taken. I think there's some learning from both sides away from this. Now, the conditions offered are appropriate. In anything you do, it has to be evidence-led, proportionate to achieving the aim, which is here, promotion of the licensing objective, preventing public nuisance, the noise limiter, the lobby, the film, the acoustic consultant report, closing of the rear outside area after 9:30, except from ingress and egress to the toilets and the signs, more than appropriate steps, we say. Temporarily, between now and doing some of those steps, Chairman, we are content not to do any live music until then. So that sort of meets some way to the question you asked me about earlier on. But certainly recorded music, we need to have it. We'll continue to do the monitoring as we have done during the busy months of July and August, and we think that that is satisfactory, and we'll certainly continue that until these works are done. We want to work with our neighbour, we want to work with our neighbours, and we want to work with the Department for Environmental Health, and we want to try to move forward in a positive way. As I say, the issue around next door and the immediate neighbour, that seems to be the only complaint outstanding since July and now, I think from my legal submission is a private nuisance, not a public nuisance, and actually falls outside of the scope of the Licensing Act. If you've got a private nuisance, it's not public. To have a public nuisance, it has to be so widespread so as to affect Her Majesty's subjects. Here's His Majesty's subjects now, and so widespread that it would be unfair for one person to take action. If I'm right that most of these objections are from the same landlord, then that would certainly be a private nuisance. And if there's only one left, it's definitely a private nuisance and falls outside of the scope of the Licensing Act. But that's more of a technical argument, because I think I've given you a practical solution and get moving forward. Unless I can assist you further, the premise licence holder, and Joe, thanks you for your time this morning in looking at all this information.
Thank you, David. So obviously now we will break for a decision. The only people allowed to remain in the room, obviously, are members, the solicitor, the local democracy officer, and Councillor Simpson will be remaining in the room as part of his licensing training, but will not be able to have any opinion or obviously speak on the decision process. I think it's just important to state that obviously if you see any of us during the break, obviously don't approach us. We're not being rude. We just can't do it. And I think because this is obviously quite a complicated case where we've got to balance the interests of both residents and obviously the business itself, and we've got to look through lots of information, I wouldn't be comfortable any earlier than 45 minutes, really. Yeah, I would say 45 minutes. So if we say no earlier than 1:30 to return for a decision, but it could be like 1:45, something like that, but no earlier than 1:30 for a decision.
Did you say 1:30?
1:30 at the earliest.
Yes. I'm wondering whether we could actually say an hour, so 1:45, so that means we can go away and get some lunch as well.
I'm more than happy with that. 1:45, we'll reconvene
We'll
earlier
get
than
some lunch
1:45.
then.
Yep, fine.
Thank you.
Thank you, everyone.
And also
Yep.
just triple check that there's no objection from anybody to the spare member, if you like. It's just merely observing. We'll not be taking part in discussions or any voting or anything.
I have no objection, and I have the assurance of the chair that it's by observation, not participation. Thank you.
Thank you.